Hello everyone, this is Zach Taylor. We also have Josh Livingston, and we're going to go over the Philadelphia v. New Jersey case. So just as a little historical background to the case, during the 1970s, New Jersey, they found themselves wedged between two of the largest cities in the United States, Philadelphia and New York City. And as such, those cities made extensive use of New Jersey's landfills and waste processing facilities. However, landfill space became increasingly scarce, and New Jersey passed the Waste Control Act in 1973, and during the following year enacted a rule known as Chapter 363, and this prohibited the importation of most solid or liquid waste that was originated or collected outside of the territorial limits of the state.
Enactment of this law, private landfill operators represented by Herbert Moore sued New Jersey. Stephen Skillman, Assistant General of New Jersey, represented New Jersey in the case. The state trial court granted summary judgment in favor of the plaintiff's grounds that the law was unconstitutional due to its violation of the Commerce Clause. Following, an appeal from the New Jersey Supreme Court reversed the decision, finding that Chapter 363 advanced vital health and environmental objectives with no economic discrimination against and with little burden upon interstate commerce. Philadelphia appealed to the Supreme Court, which found the law to be in violation of the Commerce Clause. Justice Stewart wrote this 7-2 majority opinion of the court, and Justice Rehnquist filed the dissenting opinion and was joined by Berger. This case was argued in March 1978 and decided on June 23, 1978.
Okay, some of the key facts to consider in this case is that at the outset, New Jersey argued whether or not waste could even meet the definition of being considered commerce to determine whether it could receive any protection under the Commerce Clause at all. The Supreme Court has held that all objects of interstate trade merit Commerce Clause protection, and none is excluded by definition. Furthermore, the key consideration in the case is whether Chapter 363 is an economic protectionist measure or a law that is intended to address health, safety, and environmental concerns that only have minor impact on interstate trade. And under the quarantine law, prohibiting the importation of diseased livestock, infected rags, and other such objects has not been considered a forbidden protectionist measure because they are not discriminated against on a basis of their origin, whether located in state or out of the state.
The controversy in this case hinged upon whether New Jersey law, Chapter 363, violates the Commerce Clause in efforts to place itself in economic isolation, or whether it can be viewed as a safety, healthy, and environmental concern of the state. The appellants argued that the New Jersey primary concerns are economic and financial, as opposed to the purported facade of being for health and safety of the people. The Commerce Clause has allowed for states to prohibit the importation of noxious articles, as outlined under the quarantine law, to protect the people, as previously discussed. The Supreme Court has repeatedly upheld these quarantine laws in previous cases in the regulation of commerce. Justice Rehnquist delivers a compelling dissenting opinion on behalf of New Jersey. He notes, virtually all sanitary landfills can be expected to produce leachate, a noxious and highly polluted liquid which is seldom visible and frequently pollutes ground and surface water. Therefore, it's legitimate health and safety hazard that negatively impacts the environment and should be an allowed exception to the Commerce Clause under the quarantine laws. Nevertheless, the court has upheld that quarantine laws cannot be applied in a manner that discriminates against the origins of hazardous waste. New Jersey waste is the same as Philadelphia waste and therefore cannot be considered to fall within the quarantine laws, just because it comes from a different state. Although Supreme Court acknowledges New Jersey's legitimate interest in banning waste from other states, it cannot pursue illegitimate means of discrimination in interstate trade to accomplish its objectives.
So actually the counter-argument here is that in prior cases regarding natural resources used in the states, the courts have concluded that the state is without power to prevent privately owned articles of trade from being shipped and sold in interstate commerce on the ground that they are required to satisfy local demands or because they are needed by the people of the state. In this case, the land that was owned by the private landfill operator, whom had demand from customers outside of the state, have legitimate commercial interest in their landfills. The actions of the state were clearly limiting the movement of goods, even though the goods in this case is landfill waste. Given that none of the waste at the time of movement is considered an item that is categorized as quarantine, the law of the state should be invalid as it violates the Commerce Clause.
Heard, there's two valid arguments that have made its way all the way to the Supreme Court. The Supreme Court decision argues that waste, although it may be considered valueless, merits Commerce Clause protection. Landfill waste is not determined to fall within the context of quarantine laws because it is being discriminated against in this case based on the origin and not its existing condition. Given that landfill waste is considered a legitimate object of interstate trade, states are not allowed to isolate itself by erecting economic barriers and thereby placing itself in isolation. In summary, the Supreme Court states the Commerce Clause will protect New Jersey in the future just as it protects her neighbors now, from efforts by one state to isolate itself in the stream of interstate commerce from a problem shared by all.
Okay, now we want to review a little bit of the political context as well as the impact of this Supreme Court decision. So the ramifications of this case more narrowly define the relationship between government and business. For example, the case further clarifies what constitutes commerce and what is considered quarantine in this specific case of interstate trade. Furthermore, it exemplifies the role of the Dormant Clause, which restricts states from passing laws that discriminate against interstate trade via the Supremacy Clause of the federal government. And actually, Justice Jackson further clarifies the importance of the states to act within the restraints of the Commerce Clause and not diminish its scope when he stated in the H.P. Hoods and Sons, Inc. versus DeMond case, he stated, "This principle that our economic unit is the nation, which alone has the gamut of powers necessary to control of the economy, including the vital power of erecting customs barriers against foreign competition, has its corollary that the states are not separable economic units. As the court said in Baldwin v. Selig, what is ultimate is the principle that one state in its dealings with another may not place itself in a position of economic isolation." So actually, as we discussed in class, from the tenure of FDR until the 1990s, the federal government won every case about regulating business via the Commerce Clause in the Constitution, and this case is another example of that. It further defines the grasp of the federal government on interstate trade and exhibits the role of the Supremacy Clause, where the government overturned regulations that were enacted by state and local government. And although the federal government did not preempt the local statute that was passed in the state, the Chapter 363 that we had discussed, this case highlights the importance of businesses being vigilant of the dormant Commerce Clause, which can overturn such state and local regulations.
Just to give you a couple fun facts of where New Jersey is at today and from where they came. An article out of the New York Times that was published in 1991 stated in 1972 there was 331 landfills operating statewide in New Jersey. And by March 1988, the number had fallen to 13, with just 2 more waiting permission to open. And what a huge contribution to leading to this decrease in landfills was due to the overfill of these enclosures from being completely filled up over the years. Another article that had been published in 2013 mentioned that it was titled "Toxic Gas at New Jersey Landfills Leaves Residents Fuming." So we're seeing a little more of that long-term impact that had been suggested by the dissenting opinion of garbage being left there and causing more problems further on the line.
So it turns out that Justice Rehnquist actually had a fairly legitimate dissenting opinion, which makes it all the more surprising that it was a 7-2 majority decision that New Jersey had to keep accepting out-of-state waste, because, as you can tell now, there are current issues with health and safety, and the landfills are all being completely filled up there. But then again, was that a legitimate dissenting opinion that Rehnquist had? Because New Jersey actually today is now beginning to export more than 50% of its own waste. And had it been the other way around, had other states been able to put up these protectionist measures and erect barriers, had New Jersey's landfills become filled already, they would probably find them in a position where they wouldn't be able to export their waste that they now have. So there you have it, Philadelphia v. New Jersey.